All right, so during the break, I took the opportunity, and I apologize, I went to the state's website and actually read the Code of Federal Regulations, and I think I might have misled you, so let's go back and revisit one of the statements. They have a year after all the final court proceedings to make application to the state for the recovery fund, all right? So there's a 2-year process in there, but it's 1 year after the initial court or the final court hearing that they have to make the application to get paid by the commission. They also have to try all the other legal remedies too. So they would also probably have to try wage garnishment and things like that. So they file a court suit, they win the court suit, they exhaust all the other legal ramifications like what I just said, wage garnishment, they still don't get paid. Then they have to make application to the state to get paid by the recovery fund. That application has to be within 1 year of the final court decision, okay? All of that. Seek payment from the recovery fund, initial claim to the commission in writing within 1 year. So number 3 is correct. For those of you at home, number 3 is correct. It's 1 year after the final court do they have to make application. Okay? Yes. Yes. Now, the next section is how much are they harmed? There is a $50,000 aggregate total per agent, but a $20,000 total per deal. All right? So the most the commission will pay back is $20,000 per deal or person that gets harmed, but they will only pay $50,000 total per agent that does the bad activity.
So two and a half people.
2.5 people, potentially, because there's another thing they can do. If there's more than 2.5 people, you guys remember how much cocaine Charlie Sheen did? Enough to kill 2.5 men. See, because when he left, that whole series just went downhill. That was the joke. The best joke in that whole 2.5 Men, did you guys watch it with Ashton Kutcher? He came down one day and the place was trash, and he goes, "This looks like Charlie Sheen's house." That was the most genius comment in it. If this guy steals, say, like 5 or 6 people's money, they cannot give the first guy 20, the second guy 20, because then the third guy would only get how much? 10. The fourth guy would get how much? 0. Assuming it was 20 across the board. Okay, let's make it that way. So what they would do is they can adjoin all of the court suits into one and say, we will take that 50 and divide it by 6 and give you each an equal share. That way, nobody gets completely shut out, but everybody's getting a little shut out. So you see, so if somebody goes in 1 year and they pay them 20 grand, they go in the second year, they pay them 20 grand. They go in the third year, they pay that guy 10,000 because there was 3 separate lawsuits. Right? He stole 20,000, so the commission gave back 20,000. He stole 20,000, they gave back 20,000. Third time he stole 20,000, they could only give back 10 because 50 is the most. But let's say he does all 3 of them at the same time, and the judge, they all 3 make applications from 3 separate court cases. The commission can put them together and go, you know what? 3 of you got your money stolen. 3 goes into 15. We're all going to give you all 3 $16,666 because that would be 50 divided by 3. They can prorate the money so that this guy doesn't lose 10, but they all lose something. So they can hand them out equally or individually, or they can hand the money out prorated.
But that's only if it gets filed at the same time.
Yes. So if he embezzles earnest money and there are 5 people in that earnest money account, he takes all 100 grand and leaves. You don't look like you're believing me.
Yeah.
Okay. Well, after that last mistake, I don't know if we should listen to you.
But the total they would get out for that would be 50, and they would divide the 50 between
Right.
all the people. Even if you took 100.
Even if he took 100, 50 is the most they're paying out per person. And 20 per deal. It's like a life insurance. 20 per incident, 50 per lifetime. All right? And they only pay out twice a year. June 30th, December 31st. So you lose your money, you get to court, and you make the application on July the 7th, and they go, yeah, you're going to get your money. Yeah, not till December 31st, because we write checks 2 times a year. All right? The payments made from the fund. Guess what they do with the person's license when they make the payment out for him? They suspend his license. A lot of people say revoke it. Why don't they get rid of his license? They want to keep him on the hook in case he ever decides he wants to come back in, so they will suspend his license until he pays the money back. All right? At 1% a month interest. But
Pays back the 50.
he pays back whatever they wrote out for him.
Okay.
That would be the highest extreme. Maybe they only paid out 1,000. He would have to pay that 1,000. Pays back 12% interest. Here's the other super big kick in the ding ding. My license goes with his. They would suspend my license too if he was my agent and he embezzled money and left.
You are the company.
I'm the company. I'm responsible for his actions. And he took the earnest money check and left. His license would get suspended until he pays it back, or my license would get suspended until I pay it back. Yeah. So all you guys that want to be brokers and have your own company, keep that one in mind.
What can be the possible examples of such behavior?
Earnest, you stole the earnest money. Okay. Here's a real life example. Really happened. Client was doing a deal, high-end home, like $1.4 million. He convinced the buyers to write a $30,000 earnest money check. That's not a big check for that kind of home. But the agent was slick enough to convince the buyer to put the earnest money check in that agent's name. And the agent put the money in his account and then disappeared with the $30,000. Disappeared. Last we heard, he's in Texas doing stuff. So the person wanted to get their earnest money back, so they went to court. They got a judgment against him. They won because he didn't show up. So they made application to the commission, and the commission only paid out 20 grand. So they ended up losing 10,000 in this deal because the most they would pay is 20 grand. Well, they suspended Terrence's license. Now it's been long enough, his license is gone, because I think that was been 7 or 8 years ago. All right, Randy Keys got convicted of that.
But other than, like, can you give an example other than embezzlement where...
No, it specifically says trickery, forgery, embezzlement, anything where there has to be harm. So the only kind of harm that really is involved is I stole your earnest money from you.
Okay. Not hurt your
Yeah,
feelings.
it's not a punitive thing. You can't go to the commission and say, Raymond made a mistake. I didn't win the bid because he said I should have only bid 100. So I didn't win the house. My feelings are hurt. I want him punished. That's not what this is.
Like, oh, I could have made more.
Yeah.
He cost me money.
Yes, that's,
Because he screwed up.
yeah. That would be punishment. That's still punishment.
Yeah.
All right, because you don't know you'd have made money, so there's not really harm there. He didn't put the bid in time. I didn't win the HUD house. I could have built this HUD house out terrific and won $1 million. So he cost me. I want him punished. That's not this. This is I physically harmed you through a device of trickery, forgery, embezzlement, where I ended up with your money. Okay? There's been an investigative fund to research these, and we actually pay into that investigative fund.
It's only for actual monetary losses and court costs.
Yeah. There's actual harm involved. All right? Let's talk about some other commission rules. The listing broker is allowed to offer a portion of my commission to the selling broker. Who's the selling broker again? He works with the buyer. I am allowed, or I may offer a portion of my commission to the selling broker to induce the property to sell. We call this the BAC, stands for the Buyer's Agent Commission. So when you look at an MLS sheet and your client says, I want to see this house, on the bottom of the MLS sheet, there's these three initials that say BAC, 3%. That 3% is coming from me as the listing agent, and I convinced the seller to pay me 6% commission to do this deal, of which 3 I'm giving to you as an incentive to bring me your buyer to buy this house. All right? So the commission says I can do that. The commission split is paid directly to the company, not the agent. So if you come as an agent of RE/MAX, I would pay the commission to RE/MAX, and then the RE/MAX would split with you on whatever deal they've got. All right? The action to recover fees must be provided by a party who is not in themselves in violation of the license law. So if I'm violating the license law, I can't file suit also. Hey, you're just as bad as me. I'm going to file suit against you. No, I don't think you can do that. Listing agreements must be in writing. Must have a definite expiration date. Start listing today, ends November the 17th. Must be in duplicate, 2 copies. Once again, here's a rule that our technology is outpaced. Why must you have duplicate copies of a listing agreement? Well, yeah, but so why 2 copies? Now, this is a listing agreement. One for me and one for the client, right? That's the 2 copies in the old days. Press hard, there's, what did they say? Press hard, there's 7 copies, and you got the mimeograph paper. Remember the mimeograph paper that you, and be high for like 2 hours? See, you young kids miss all that stuff. You go down and be the teacher's pet and copy paper and walk back. Dude, just copy 300 pages, I'm high. Now with electronic copy, we end up with 47 copies by the time you're done. Here's a copy that I sent to you. Now you signed it and sent back a copy, so now I've got 2 copies. So one of those isn't good because it's unsigned, so I got to figure out which one's to sign. So listing agreements must be in duplicate, all right? You cannot have a net listing unless you disclose it's a net listing. I do not want to go into what a net listing is yet until we get to chapter 7 or 8. Just realize a net listing is illegal unless you disclose it. A net listing, real quickly, is when a person says, I want to sell my house, I'll take the first 100,000, anything you sell over it for 100,000, you can have. That's quick version. Offers of purchase or a purchase agreement, once again, must be in writing, must be in quadruplicate. Why quadruplicate? This is the old days, remember. 1 for me, 1 for my client, 1 for you, and 1 for your client. That would be 4. I would write an offer for my client, the buyer. So there's 2 there, 1 for my buyer to have, 1 for me to have. I would give you 2 of those, 1 for you to keep and 1 for you to give to the client, ultimately. Got to be in quadruplicate. Now, like I say, in technology, we've got digital e-sign. There's 1 copy that everybody signs, and technology is completely changing this stuff. Every managing broker shall deliver to their client at the closing transaction a complete and detailed list. Once again, If you bought a house, you know, when I told you the girl walks back and hands you the documents and the buyer reaches up and takes hold of it and the property transfers, technically those documents should be given to the broker, who should look through them to make sure they're all there, and then they hand them to the client, because that's our job, to make sure our client has all the documents. That's what this is saying. It's our duty to make sure our client has all his own documents at the closing statement. Closing. I make sure I have my clients, you make sure you have your clients. I'm not responsible nor liable for your client's documents. Brokers must attend a closing, or my assigned designated representative who is licensed, because there could be still questions there. And remember, talking about real estate's a licensed activity. So typically what happens is you got a new client that's your mother, and you come running into me, hey, I got a new client, it's my mom. No, you don't. I have a new client that's your mother, and I will allow you to work with her. That's how it looks. Then when closing comes, I got to go to the closing. Well, I will designate you, since you've done all the work already. You can go to closing and bring me my check. All right? All advertising must include the broker company's name. You cannot advertise as if you are the company. If you're going to write Raymond Modulin, it better say the Modulin Group somewhere, because you are not the agent, I am. Must clearly state the broker's name as it appears on the license, or publicly known, like the Modulin Group is my public name. It's the DBA. That's funny, that's a law that's changed. The old law used to say that my name had to be bigger than your name. So if you advertise like on a billboard and you wanted to put Holly, that's fine. The Modulin Group had to be bigger than your name. So there was never a distinction or a misrepresentation that you were not an agent. Because remember, we have to disclose that. Now they've changed it so that it just has to be present. If you have an internet, television, or radio ad that carries the name of the broker, it must also include the broker's name. So anytime you advertise, you've got to put, Raymond Modulin, Carpenter. It's always got to let people know that who you're affiliated with on every form of advertising, period. Now, there is this one thing now that they're allowing on Twitter. You can have hyperlinks to do that, because Twitter's a limited number. So if you tweet something out, Raymond Modulin Realtor, there could be a link to the homepage that says the Modulin Group and all that, because of a limited space. So some of the internet stuff allows you to use links.